The Supreme Court just came down with a major decision. How is it going to affect immigrants who are in removal proceedings? Listen today to Immigration Wednesdays to find out. Hi, I'm attorney Jeff Peek, and last Thursday, at the end of April, the Supreme Court had a major decision, Niz-Chavez v. Garland. In this decision, it's going to affect everybody who's in removal proceedings. And let me explain to you what we're talking about. Of course, removal proceedings, we mean deportation proceedings. They changed it to removal proceedings a while back. Anytime somebody's picked up by immigration, detained, whether they got arrested for something else or the immigration runs into them somewhere in the country and they detain this person, if they want to initiate deportation proceedings, they have to give them a document. This document is called a notice to appear, affectionately referred to as an NTA by immigration people. And in that document has several things. It states your name, your date of birth, where you're from, and then there's some accusations. And part of the accusations say you're not a U.S. citizen, you're a citizen from this other country, you're here out of status, either you entered illegally or you overstayed your visa, and then it states the immigration rule or a section of law where you're removable or deportable or inadmissible. And then it goes on, and at the very bottom, it says in there where your court is going to be, and it says the place, the time, and the day. Now, the law seems pretty clear and has always been pretty clear that that NTA has to include that information about the date, the time of clearance, place, and time. After all, it's called a notice to appear. And the whole document's labeled out of where you're going to go and what time. But for practical purposes, immigration for the last 20 years has basically been ignoring that the law said they had to put a date and time in there, and they just said, will be determined later, right? Like, we'll give you notice later about that. Here's your document now. And then they would just send a letter in the mail later on, or a letter to your attorney if they needed to change, or once they had the court date, they're going to do that. And the reason being was, we don't have time to call the judges and coordinate between administrators and give you a court date. Well, some immigrant appealed that. In 2018, we had a case called Pereira. And in the Pereira decision, the Supreme Court came and said, that's a defective notice if it doesn't include those things. Well, if you remember, in 2018, we were under the Trump administration, and his Attorney General Jeff Sessions and him didn't like that very much. So they decided to come up with a quick reinterpretation of the Supreme Court's decision through the Board of Immigration Appeals, which is another alternative immigration, kind of the immigration Supreme Court, if you will. And they basically carved out an exception for themselves, saying, no, well, the way they're interpreting that is you can still send a letter to supplement that original NTA. So they kind of reinterpreted the decision, which seemed pretty black and white of what they were saying, that your NTA had to include the date, the time, and the place. Well, here we are 2.5 years later, April 29th, the Supreme Court rules again, basically reconfirming this purpose that the NTA is defective if it does not include those dates, those times, and those places. Well, what does that mean, and why does that affect so many people? Because pretty much every immigrant who's been placed in removal proceedings for the last 20 years didn't get a date, a time, or a place. That means all are going to be able to potentially attack this decision, and there's a couple of ways that might happen, and you need to talk to your attorney. One way is they might be able to convince the judge to throw the entire case out. Another thing could be is it now allows them to say that they have continued accumulating time here in the U.S. and they might be eligible for other defenses like cancellation or removal, which requires 10 years here. And because that document's defective, it didn't stop the accumulation of time here like it's supposed to under the law when you receive the NTA. And so now, maybe you've got the 10 years here and now you can apply for that defense. Very important, you talk to your immigration lawyer to see how this new case, Niz-Chavez v. Garland is the name of it, could affect your immigration status if you're in removal proceedings, or how it might give you additional defenses and a chance to stay here. We're very excited about it. If you need any help, if you want to talk to an attorney here at Peek & Tone, we'd love to talk to you. Have a great week.